Nowadays, what is happening is that CCI tells very clearly if you are going in for a merger, acquisition, or whatever factors altogether, if there might be some factors here which needs to be controlled, which needs to be understood, which needs to be taken fact, there are certain areas where the clarity has to be given in terms of how India businesses start merging outside, what are all the collaborations, what are all the factors, a clear set of rules and regulations which can go forward, make you explain the challenges, the factors, and keep the entire industry. Good morning and welcome to the Session 6 Unit 5 Commercial Law, where we are going to talk about the merger control in the Competition Act. Now, as we go further, mergers and acquisition are a very big thing when it comes to that factor of competition. I merge and then I take over the control. So in the first 2 years of merger control, India has been interesting in several ways based on the review of functioning of the regime, because for the first 9 months, CCI saw the fit and amendment altogether. So what they used to do is that they wanted to bring in a lot of restrictions, and the regulations of 2011 and amended finally in 2012 came into picture, especially for the merger control factor. The regulations evoked a mixed reaction in the industry because there was pros and cons about it. People started looking at it as an opportunity, also as a factor of growth, and challenges also, because most of the industries were in the position of merging, of takeovers and other factors. But then they had a lot of changes coming up. Again, in April 2013, there was an amendment for that stream. Now, moving further, in the little over half year about that factor, and a year and a half, CCI has reviewed about 100 mergers. Despite industry fears regarding CCI's ability to clear transactions in a timely manner, but CCI has continued to meet its commitment and has kept up its words at any cost at any point. In fact, CCI has even cleared the 2 detailed Form 2 notification that it has received on day 30 period altogether. CCI was also able to establish a number of key principles since its introduction, which will shape the competition law regime for India. For example, through its decision, CCI was clearly able to set out what constitutes the control under the Competition Act altogether. So it was able to go and tell people exactly what do we mean by competition, what are the rules and regulations that we have to follow, and how we have to maintain in terms of factor. Though there were many industrialists who were against it, who did not feel about it, but then we bought in the merger and control activity altogether here. Followed by, fundamentally, an investment made by an enterprise which leads to the acquisition of control over other enterprise will require notification from CCI, provided the transaction meets the asset size or the turnover thresholds, goes above the prescribed limit in Section 5. Nowadays, what is happening is that CCI tells very clearly if you are going in for a merger, acquisition, or whatever factors altogether, we want to see here that there will be a notification that has to be sent from the CCI, and approval has to be sent moment the asset size is going beyond the prescribed limit. This is purely because CCI wants to understand what are all the change factors that are involved in this act altogether. So if there might be some changes, if there might be some factors here which needs to be controlled, which needs to be understood, which needs to be taken fact altogether, those things have to be told very, very clearly. If those are not prescribed, those are not met, the factors of things are not being achieved from the CCI, then automatically the mergers and acquisitions will not be approved altogether. Moreover, if an enterprise is said to be in control of another, the two will qualify as a group of companies under the Competition Act, exposing the different set that has been of assets and turnover. So moment you start controlling somebody, you start acquiring somebody, what will now happen is you will become a group of companies. So that group of companies will have a dominant effect on the market. They will try to control the market, they will try to control the size, they will try to create a dominant position altogether. So definitely that is going to come into picture in terms of understanding. Followed by the question which then arises is, when do the rights secured by an investor cease to be mere an investment protection right and become also extensive, that CCI treats them as leading to control? For an investor, now what happens is that when I put money in the shares of Tata Motors or in the shares of ICICI Bank or in some other company altogether, I am just an investor trying to look for some profits. Because if the company grows, the share value grows, I will be able to make some profit in the long term. But what happens here is that the company just takes me as a mere investor who has the rights of only investing and not looking into the profit at any point of time. So automatically what happens here is that I want the investor to get empowered from just an investor to a person who can go and tell CCI about the control factors. Why this company is acting in this way, how these companies are becoming dominant in the market, what we need to do to control their rights. So those factors are to be discussed. The next thing is CCI is in this one of its mergers decisions and observe that in some cases the veto rights enjoyed by minority shareholders over certain strategic commercial deals can result in the situation of joint control. So there is some sort of a hold that is being done by this minority shareholders who will in turn give the company a strategic position, a strategic hold altogether, which is not being accepted, which is not being achieved by that CCI altogether. Further, in line with the guidance of the European Commission's joint jurisdictional notice, which has been noted under this particular year, the CCI specifically identified certain types of negative rights that could confer control, being veto rights in relation. Now, for example, commencing new line of businesses or opening offices. Now, this is purely something which has to be discussed. Moment people start identifying the strategic market, again, they start opening up, become dominant there. So CCI wants to prevent it. Discontinuing from an existing line of business, you cannot just take over any business at any point of time. You cannot just discontinue, move into a new segment, leaving the customers and leaving the investors in the lurch, which will not be accepted at all. Followed by appointment and termination of key management personnel, including materials of their employment. Suddenly changing people, suddenly bringing in drastic change in your management structure is also opposed by the CCI, because they feel that this is not something needed at this juncture. They feel that this is not of a good thing altogether. So there might be a questionable factor. Material terms of employee benefit plans, which has to be questioned. The approval of annual operating plan, which is also very, very important here in terms of understanding, because all these things the CCI will definitely question. They will not just accept on the fact, on the behalf, saying that yes, it is done, so you will just take over it and you can run over that situation. This will never be considered to be good at all. Followed by the CCI's focus on bringing in the merger regulations in line with global best practices is good for the industry. Today in India, when we talk about competition, we want the competition to be in lines with the global standards. We are no more a local country producing only for us, but we are a country where we are trying to produce goods across the globe, across the continent altogether. So however, certain uncertainties are there in terms of answering, especially the merger regulations list certain type of transactions that are ordinarily not likely to raise any kind of concerns, or normally what happened, they exempt from the notification altogether. This includes the deal for taking place outside India, insignificantly local nexus, effect on markets in India. There are certain kinds of, cartelism, there are certain kinds of groupism, especially when you talk about business ranging from outside, ranging from the other factors where the mergers, regulations and listings and other factors are also looked upon. CCI says that there are certain areas where the clarity has to be given in terms of how India businesses start merging outside, what are all the collaborations, what are all the factors that has to be taken into picture. Unfortunately, CCI has not shed any light on what it would constitute an insignificant local deal or nexus markets in India. Decisions date indicate a very less of effect analysis as far as the offshore transactions are concerned. So it is very clear that decisions indicate a less than of the effect analysis, which means to say that they tell very clearly here that what kind of factors, what are all the importance that one has to look in terms of the effect that has taken place, in terms of the market effects. Suppose we are tying up with certain companies, we are tying up in certain markets. What kind of effect will be seen in that kind of situation? That has to be seen here. If the parties meet the turnover asset thresholds as prescribed by the CCI section 5 altogether, then the trend has to notify that it is unclear of the additional factors. It is completely taking into position whatever the factors that are already taken into consideration, how the local nexus is formed. There are certain things which are unclear here. So what we are trying to understand here is that what additional factors that CCI has to look in terms of understanding the business at any given point of time. If those things are understood, if those things are being clarified to a greater extent here, then automatically this can lead to a better control. Now, there is an ambiguity over the calculation of turnover. We do not know most of the time. The turnover calculation is not correct in India. So there is possibility that might lead to some sort of change, some sort of factors altogether. The Competition Act simply defines turnover as the value of goods and services and no guidelines on how to calculate the turnover on different types of business, which is very evident here. One of the decisions is that the CCI addressed the issue specifically in relation to the travel agents. Why? Because CCI finds that whenever we are talking about travel, tourism, hospitality, we are not able to understand the business that is generated overseas, how it is being calculated, how things are being taken into position, that we are not knowing it. So the merger control in that particular specific area is definitely under question mark. Followed by when an enterprise organizes package tour on consolidated amount, CCI has always been worried about that gross amount, net amount, how much it is being calculated, on what basis are you charging up that fees, and on what basis the enterprise is actually taking into consideration the profit-making factor. So, for example, in the case of Fairbridge Capital Mauritius and that of the Thomas Cook Limited India, these cases were very evident, trying to question back on the company how they had evaluated their turnover, how they had looked into the different aspects of the business. However, the likes of mutual fund or foreign exchange accounts have yet to be found out. So many times it happens for CCI that every day they are trying to find something new, they are trying to find something different altogether in spite of the challenges that have been mentioned. Now, when an enterprise that organizes and those factors are coming in, and we also need to see the more complex transactions are notified here, and you will be able to see that there are a lot of ambiguities, there are a lot of challenges that are coming here. Till now, CCI has shown and demonstrated an inclination to be responsible to stakeholders, and CCI has maintained its stance very clearly. Though they have gone ahead and tried to explain the ambiguity, they have also gone ahead and tried to explain all the charges, all the factors, saying that where we want to come forward, where we want to guide, and where we want to tell people what exactly is happening in the market. Now, you will be able to see that in the competition law of India, due to undergo of a massive change in the future, the competition amendment, the substantial factors have been told, introducing specific level mergers or introducing of joint or collective dominance. All these factors have been explained, followed by extending the power of search and seizure, by the Director General to cover on dawn raids, what has been taken into picture, giving the parties to an opportunity to be heard in the quantum of penalty. Even those factors have been taken in the Competition Amendment Bill of 2012, which is coming into picture, which is a very, very big improvement made by the Government of India in terms of the dealings taking place, followed by industry-specific standards. They have brought in threshold levels have been lowered. Currently, they have told it, and they have also brought in better transaction principles that would unlikely cause an appreciable or adverse effect on the competition, followed by particularly the low threshold could end up defeating the de minimis exemption altogether. So they are even worried about those factors. So what they are trying to look here is that a clear set of rules and regulations which can go forward, make you explain the challenges, the factors, and keep the entire industry even more intact. Another area of concern is the joint or the collective dominance, which still remains undefined, no doubt about it, because when we talk about the Section 3 and Section 4, there needs to be an increased clarity which has to be given by the companies, and it is still worrying because we are not able to get the exact picture in that factor. On the positive side, the possibility of dawn raids made by the Director General will enforce the business to strengthen their in-house competition, establish better rules, fairer transactions, better, opportunities, giving the parties the right to be heard. The quantum of penalty is likely to bring relief to the enterprises and other factors. So definitely, when you look into all these opportunities that has been given here, what we are trying to do is make the competition as fair, as healthy as possible, so that the industries can take forward and bring in a better opportunity here. So definitely this is going to be a new opportunity, a new dawn that is coming into picture. The CCI's decision on the anti-competitive agreement abuses of dominance, or when we talk about merger control, is a symbolic of the fast-growing regime. Now, this is where CCI is coming up and telling it to the corporate India, no more it is going to be a single-man show or a single dominance, but we are going to control the trend and the lean towards establishing greater familiarity, transparency, bringing in economic improvement, bringing in better transparency in terms of running the business, making you understand how the system is working. All is going to capture a great amount of help, and this is definitely going to improve the quality of transactions that are happening in India. The business is definitely going to take a leap forward. Now, the conclusion that I would like to say here is that CCI must arm itself with newer and more sophisticated tools of investigation. This is a learning for CCI that they have to start building a better systematic way of investigating with further evidence, with further clarity rules, so that every merger, every acquisition, every activity of the market is clearly told to the investors and other people as what they are doing. Despite being a new field of competition enforcement, the extremely important proactive stance that is taken up by CCI in the past 3 years is a sign of a greater India movement, a greater transparency, and yes, we are going to see a more competitive economy in the coming years. With this, I come to the conclusion of the session. I hope and believe all the factors, all the information told here will be of a great importance and a resource. Thank you once again for joining me today on this wonderful session today.